I wanted to run through a specific case because reading it blew me away that you were able to do what you did to the accused. It was a murder and manslaughter charge. The client's sister testified that she helped her brother clean up the murder scene at the house and saw him wrap the dead man's body in a blanket before the body was dumped on a lonely stretch of a public road in Austin. Do you remember that case?
Of course, I remember it.
How did you, first? How did you do it? How did you do that? Because I would assume a sister telling a jury that my brother did something is about as guilty as you can.
Except that you wonder why you would wait 9 years to come forward and do it.
Wow.
And then you think, wait a minute, lady, do you have another reason that you're coming forward now to accuse him of something that far in the past? You sat on that knowledge all of these years for what? Because you loved your brother? Why did you stop loving your brother? Oh, are you fighting over property, ma'am? Has someone in the family died? Have you decided that you'd rather inherit all the money than split it with your brother? And so now you remember that, oh my God, he committed this murder. And remember, that was the only evidence of his involvement. No fingerprints, no DNA, no other human being who could in any way support that story. That's how I won.
Now, is there a statute of limitations in terms of when you can report a crime? Because 9 years seems like a very long time.
It seems like a very long time, except that the crime is murder. Are there statutes of limitations? Yes. But murder is always going to be hanging out there.
Really?
Yes, really.
Got it. That's actually a very good point. You talked about waiting 9 years over some land or things like that. There was another case as well where the individual was charged with a sexual assault of a child. The client confessed in writing to sexual assault of a child. The confession was admitted into evidence before the jury. What does that mean, the evidence was admitted?
That the state was allowed to prove that he had confessed. They had his confession. It was in his own writing. They introduced it through one of the detectives, and the jury got to hear the confession, and the confession was given to the jury when they were out deciding guilt or innocence. That's what that means.
Are they supposed to have it before? Or not at all? Or
No, I mean, the confession comes in as part of the presentation of evidence. You know, you have the detective on the stand and you say, Detective Smith, did you speak to Mr. Sawyer's client? I did. Did he do that willingly? Yes. Did you take a videotape of that? Yes. Did he eventually give you a statement in his own handwriting? Yes. I'm going to show you what's been marked as states number 15. Do you recognize this? Oh, yes, sir. This is the statement he gave us in his handwriting. And Judge, I offer this into evidence. You can't object to it. It's your client's handwriting. Judge admits it into evidence, and now the jury can consider it, and you get to read it to the jury, and they get to hear it.
was that his actual handwriting?
Yes.
Was? And so how was this individual eventually presumed not guilty?
Well, the jury found him not guilty, and I proved that he had given that confession because of the way that they interrogated him, that they intimidated him, that they scared him, and that he could never have done that.
That is wild that police have the ability to do some of these things to get a guilty verdict or to get someone on arrest. When it comes to a case like this or the case before where the woman comes to the police after 9 years and you're accused of something, is there a way to get that money back that you had to spend to prove your innocence, or is that just...
No. It's money that you spent because you were criminally accused, or money the state spent if they had to appoint a lawyer to represent you.
It's the cost of living and doing business in the United States. Another case: 6 separate felony acts of sexual assault on a child. The child testified to the jury that she was repeatedly sexually assaulted by the accused. Now, before we talk about this case, I assume you are a parent.
I am.
Correct.
Do I have a daughter? I do. Do I adore my daughter? I do.
You know where I'm going, and I think I know the answer, but how do you separate you being a father with you being the lawyer that needs to represent someone that is accused of these heinous crimes?
You don't separate yourself from that. The question is, can you in fact go ahead and represent the accused? You know, one of the things you're not asking me is, do you have a very candid conversation with the accused? If he says he didn't do it, do you form an opinion of whether you believe him or not? Sometimes you can't agree to represent an individual, and you have to tell them, Mr. Smith, I'm sorry, sir, I can't represent you. And if he pushes you, you tell him, sir, I don't believe you. When you do, then you will give it everything you've got. In that case where the little girl testified, I took her through a lengthy cross-examination. I got relatives who came and testified that they had caught her having really strange sexual contact with a dog. And in the final argument, I looked at her. She was sitting out there in the courtroom and said, we're never going to know what's wrong with this little girl. And she shot me the finger in front of the jury. Wow. So, yes, I mean, those are the things that perhaps a jury considers in finding your client not guilty.
Was there ever a case where you believed your client was innocent and they were found guilty that stuck with you?
There is no lawyer who practices criminal law who has any extensive experience that hasn't known the pain of having a jury return a guilty verdict when you really believe that they're not. Can that happen? Yes. Does it happen? Yes. Sometimes they return the guilty verdict because the state is able to prove how many times they've been to prison. And that alone undermines any chance of them believing your client when he's testifying. Criminal law can be very, very, very punishing.
I saw your face and your emotions and made me realize that is probably one of the more negative sides of being a criminal defense attorney when you don't get a win and you thought you would.
It's not a matter of thinking that you'd get the win. It's really the pain that comes with thinking, dear God, did I do everything I could do? Because I believe this man or I believe this woman. And, but again, it's part of what you assume. It's what you take on when you decide you're going to do this work.
Now, when you receive a guilty verdict, is there any steps that can be taken to appeal the decision?
Well, you can appeal any criminal decision. You simply announce your intention to appeal. You file notice of appeal. If they can't afford to hire you for the appeal, you get an appellate lawyer appointed. Our system really is, I think, the best criminal justice system in the world. And no one comes close.